All right, everyone. Well, welcome. Really excited to be here with you today. This is a topic that's near and dear to my heart. We're going to be talking about how to avoid big startup mistakes. And as with all my presentations, just want to make sure I take a quick second or two to talk about, don't consider anything that I say today as legal advice. I'm going to be talking about some general principles and concepts, but they may not be suitable for your specific situation or your particular circumstance. So you should always make sure that you engage, counsel if you've got a particular issue that you need help with. Make sure that you can provide all the facts and background, and then get a proper legal assessment and advice. So nothing that I say today should be considered or construed as creating an attorney-client relationship or attorney advice. Okay. So just a little background on today and what we'll be talking about. I'll go over my background and what I do on a daily basis, a little bit about the firm. I'll provide a little overview about, why I think this is a really good topic to talk about and share with you today. Some of the goals of what I hope to accomplish with some of the issues that I'll be addressing. And then talk about some specific areas. So documenting your deal or documenting a transaction, capitalization, good corporate hygiene or good corporate record keeping, if you will, preparing for your first deal, and diligence. And then we'll save some room at the end for some Q&A so people can ask some questions. I know you may have questions throughout. There may be some, I'll try to answer some if I can, but for the most part, I'm going to try to reserve about half an hour or so at the end, and then I'll run through as many of the questions as I can. If for some reason I can't get to your question, or if you wanted to talk to me about a particular circumstance, feel free to email me afterwards. I'd be happy to set up a time to chat with you privately. Okay, so a little bit about my background. And a little bit about our firm. So I'll start with the firm first. We're a fully integrated, full service law firm. We have over 40 offices on 5 continents, about 1,900 attorneys. And we have a large history of working with a lot of startups, emerging growth businesses, as well as more mature, larger companies. We do a lot of work both on the company side as well as on the investment side. So we represent not only the startups, but also a lot of the investors, venture capital funds, private equity funds, what have you. So seen both sides of the transactions and have done a lot of work in different areas in different industries. I'm in our corporate group. I enjoy working with entrepreneurs and startups. Most of my practice is focused on working with private companies, generally in the earlier phase of their life cycle, startups, early stage, mid stage, late stage, emerging growth. And it's really from sort of A to Z or life to exit, if you will, and everything in between that comes up. It's been great working with a lot of people, seeing the innovations and creativity that people come up with and how they're able to solve pressing needs and offer solutions that are, in some cases, something you thought was very simple, or in other cases, something that's incredibly complicated. So let me do this right now. I'm going to send out a poll, just a couple of quick questions, just to get a sense of where people are from, and also, whether you're a first-time entrepreneur or you serial entrepreneur or you're involved in an early stage company. If you could take a few seconds or so and answer those 2 questions, it'll give us a much better sense of where you are, as well as sort of what your status is. I'll give it another maybe 15 seconds or so. Okay, so let's see. All right, a few more seconds. Okay, so, and I know a lot of people didn't answer, but anyway, so just a real general sense of where we're from. Looks like about 18% are in the Bay Area, about 46% in other parts of the US, 4% in other parts of North America, some people in South America, Europe, about 18%. So it's a pretty good mix. Asia, Africa. Well, anyway, all of you, welcome. And if you're up at an early hour, as I know someone is from Kuala Lumpur, my hat off to you. It's not easy to get up to listen to a presentation early in the morning. Okay. I always like to start off sometimes with an interesting quote. This is one I've used before. Henry Ford has a lot of quotes, but this is one I thought was particularly interesting. Failure is simply the opportunity to begin again, this time more intelligently. And really what it means to me is you learn so much from failure. And maybe failure is not the right word, but oftentimes if you talk to successful entrepreneurs, you oftentimes will hear the same story. You know, I got knocked down, I fell down, this didn't get done right. I kept failing until finally you hit it and were successful. And it was a lot of times the learning moments that came from those early failures that allowed the person to ultimately achieve success. So tremendous amount of opportunity to learn from failure. Hopefully today's focus and today's goal will be you're going to fail no matter what. You're going to have to get up and keep going as you start on this startup adventure. But if we can help, or if I can help sort of steer you away from some of the bigger mistakes, that's sort of the goal of today's discussion. So I'm going to be using real life examples. The names of the innocent have been changed, but to protect their information, but I'll be using actual examples that I've experienced over the years representing clients that have had missteps, tripped over an issue, didn't handle something properly, something went sideways, and hopefully all of those will be opportunities that you can take away and learn from as some of the types of mistakes that can be made with startups. So the very first topic, documenting the deal, is really one that's super important. It sounds pretty common sense. Yes, of course, you should document a deal, make sure you've got, an agreement. But I can't tell you how many times I see this over and over again where, whether it's the entrepreneur or the founder, there isn't a good agreement in place. There wasn't the time taken to properly determine what type of agreement should be done, time to speak with an attorney to get good advice on actually preparing the agreement, or have the attorney prepare the agreement, or even to explore the relationship enough to know how best to arrange the agreement to govern that relationship. So one example, which I sort of refer to as the napkin deal, one of the more interesting deals I've seen over the years, was where there was a founder of a company. It was a really interesting, innovative device. He created a device that would allow you to use it with videography and photography, and it was a lighting type technology. Really cool, really innovative and creative in the way it was designed. He was the designer of it and had everything he needed for the design. He just didn't have a good manufacturing solution. He had a really good friend, and his friend and he were talking one day, and they talked about, hey, why don't you provide the manufacturing services? I've got the technology, I've designed it, I've developed it, and together we can go ahead and manufacture this and get it out there. So before that conversation took place, the founder had actually started a Kickstarter campaign, and had gotten a ton of interest from a lot of people. Everyone wanted to buy this device as soon as it was ready. So there was obviously, the clock was ticking, and they needed to be able to manufacture it to be able to supply to the people that had signed on. So after a couple conversations, they signed a deal. It was an actual one-page agreement. I see very few one-page agreements, but this was one of those. They signed the agreement. After a few weeks, after a few months, the friend just couldn't deliver. He couldn't manufacture the product. It had defects. It was, there were cost overruns. Now, let me back up for a second. The agreement they signed, essentially, the founder gave his friend 50% of the company. And there was no conditions. It was basically, yeah, you get 50%. I'm going to have 50%. You're going to do manufacturing. I'll do all the other stuff. Well, the relationship broke down. There was a lot of frustration. And eventually the friend just walked. He said, look, I can't do this. I've got a whole bunch of expenses. You should be paying for the manufacturing costs. And the founder said, wait a minute, I gave you 50% of the company. I wasn't expecting to pay any of the costs. And of course, none of that was covered in the agreement. So I don't know if you've seen this scenario play out before. I certainly have. You never want to do a napkin deal. You always want to make sure you're documenting your transaction in a way that's clear and really encapsulates the relationship in a way that will allow everyone to understand what it is that the people are doing, what are the rights, responsibilities, etc. So fast forward, the founder ended up having to buy his friend out of the 50% interest that he had given him. And it cost a pretty penny. It was $75,000 to settle and buy the interest back. And essentially he got nothing for it because his friend couldn't deliver a manufactured device that worked properly. So the key takeaways, right? Do your diligence, troubleshoot, ask the tough questions, make sure you get legal advice, document your deal properly. Those are critical. And so doing your diligence, I mean, yes, he was a very close friend, but could the founder have asked a bunch of questions to understand, well, how much, what's your current manufacturing facility like? How much can you handle? Who's going to cover the costs for the actual ingredients, the materials that need to be used? What's your time frame? Are you so busy you're not going to be able to take on new business? What do you expect from me in connection with your involvement with the company and to provide the manufacturing? What can I expect from you? And what if there's delays and other issues? How do we handle that? The best way to do that, I found, is to just ask a lot of questions, the what if questions. What if this happens? What if that happens? And eventually you'll start getting answers where you can then sort of figure out, okay, I need to make sure we cover this contingency, or I need to make sure we cover this scenario that might come up. And that's really important and valuable information, because that'll help then guide you, and hopefully you're involving your lawyer to create an agreement that will mitigate some of the problems that could otherwise come up. There's no such thing as a bulletproof agreement. Things can always go wrong, disputes can always come up. But if you've covered enough of the areas and you've really had a clear, well-written agreement that can govern the relationship well, you've done the best job you can do to avoid some of those issues from becoming problems. Because, well, here it is. It says exactly the manufacturer is going to provide all of the raw materials necessary to produce X number of units. Well, if it's already agreed to in the agreement, less likelihood of there being a dispute as to who's covering what and who's doing what. The last item there, I talk about resolution, and it's really unusual how this seems to keep coming up. There's almost a 10 times multiplier if you don't do things properly, and then you have to clean it up after the fact. I've seen this play out a number of times where the cost to resolve it once it goes wrong has been, in some cases, 10 times or more than what it would have been to have just done it properly from the get-go. Okay, so we talk about importance of documenting your deal, making sure you've sort of asked the what if questions, you've really explored the relationship, you kind of know what you're getting into, do your diligence, so to speak, your homework. Now it comes time to actually document a deal. How do you document a deal? Well, there's a number of different ways, and it depends on the type of deal you're documenting, what the transaction is. But I'm going to just give you one example, because I know a lot of people, assuming you're startups or entrepreneurs, founders, at some point in time, you're most likely going to go out to raise financing, and you're going to want to have a term sheet, whether you prepared it or whether the investors prepared it. But that's sort of your starting point of looking at all those what ifs and issues that you should be thinking about to have a formal agreement prepared. It's a very short, it's a term sheet, as they call it, or an LOI, letter of intent, or MOU, memorandum of understanding. It's a shortened, condensed document that will essentially provide you a snapshot of the most important terms that relate to that transaction. So it's very easy to get on the same page with someone if you have sort of a term sheet that lays all those really important terms out. It's not going to include everything, but it'll include enough of the terms that then, once that's agreed upon and everyone's on the same page, that can then be taken to your lawyers to prepare the actual definitive agreement, the final agreement that'll be signed between the parties. But it's a really critical step, and really important if you're doing financing or fundraising, but also important in other scenarios too. If you're going to, for example, do a joint venture with another entity or individual, or if it's an important enough contract where it's the first type of contract you're doing, there are a lot of issues that you need to be thinking about. You could even use this sort of approach with a commercial type agreement. So essentially what you do is outline the relationship, who the parties are, what the key terms are, timetable, obligation of parties, the term sheet, letter of intent, MOU. It can be binding or non-binding, or it can be a hybrid of both of those. So some parts might be non-binding, some parts might be binding. Typically, we oftentimes will look at confidentiality and potentially exclusivity as being binding pieces of or parts of that term sheet, and then the other parts are not binding. And the idea is that you don't want to be bound to something yet, because this is still too abbreviated of a document to really be something you want to be bound to for the most part. It's not until you've got alignment on the basic terms and then you go to the definitive terms. The definitive agreement is what you want to be binding, and that'll be signed by the parties and enforceable if there's an issue. But the term sheet, oftentimes you don't want a lot of those terms to be binding, except maybe confidentiality and exclusivity. Transaction expenses can also be included. Oftentimes with the financing, they are included. In other types of transactions, you may not include those. So a quick note on term sheets: they have to be drafted very carefully. Definitely get your lawyers involved. I've seen plenty of situations where client comes to me after they've already signed a term sheet, and then once you review the term sheet, you realize, well, geez, you didn't really negotiate for this, or this is not really market. Why did you agree to these terms? Or this is not favorable to you. Was there any discussion about this? Or other terms that should be put in there that aren't put in there. So the time to get your lawyers involved is actually the very earlier part of the stage, not at the later stage. It's really critical. Okay, let's move on now to talk about another topic. And actually going back, just giving you one example. So, I had a client that came to me. They were negotiating a financing, and they had pulled some term sheets down from a Google search, looked at a couple, drafted one, sent it to the investor, got some comments back, and then went ahead and signed it, and then came to me and said, hey, we've got this financing. Can you help us with the financing? And I said, sure. Where's your term sheet? So they sent me the term sheet. And upon reviewing it, I realized, okay, well, this is the deal you kind of agreed to. And there were a bunch of things that have been left out. There were a bunch of provisions that were very favorable to the investor, but not favorable to the company. And had a discussion with the client, pointed those things out. And of course, there was that aha moment that, oh, shoot, I wish I'd gotten you involved earlier in the process to help me negotiate a better term sheet. Even though term sheets are not binding in a lot of cases, it's very difficult once you've signed a term sheet to then go to the investor, if it's financing, and say, look, I know we signed this term sheet, but I really want to have a higher price for my stock, or I want to have, this provision done differently. Again, it's not binding typically, but that could potentially, ruffle feathers and sour the relationship with the investor. It's just not something you really want to do. Okay. So let me go forward here. Documenting your deal, critical. Can't emphasize how important it is. Make sure you do it properly from the get-go. Don't wait until later in the discussion to go and talk to a lawyer. Another area I see where there are a lot of mistakes are when you're starting a company, creating your cap table, how you manage the cap table. And essentially the cap table is the table which shows you the ownership of the company. It's where you see, who the owners are, who has stock, who has options, who has a safe, what do they have? And it's where oftentimes you'll focus on that because you want to see what's going on with the ownership of the company or the potential ownership of the company. If you're going to do a financing and you're going to take on a new investor, how's that going to impact the existing investors? So one example that came up, and this was really poor management on the company side. Small startup, very successful, great technology, but they tended to do a lot of things internally, didn't get good legal advice. So they set up the company with a minimal number of authorized shares. Those are the number of shares that the corporation is authorized to go out and issue. And think of it as a checkbook. You've got $1,000 in your checkbook. You don't ever want to write a check for more than 1,000 because it's going to bounce and it's going to cause problems. Same concept with the corporation. You can increase your authorized shares, but you got to amend your charter to do that. If you don't amend your charter, you're stuck with the amount of authorized shares you have. So in this case, they had a small amount. I think it was about 10,000 or so. And they wanted to split their stocks to make more shares, right? So they did two different stock splits. So they did the one for 10,000 split, and I think they did another one for 5,000 to get a higher number of shares, so that they had more shares that they could give options to people, and they'd have more zeros at the end of the document they're giving them, which made the employees and consultants feel better. They're getting more shares, even though the value is the same. It felt better, and they wanted to do it. So they did the documentation, they prepared it, they sent everything out, but they never actually amended their charter to make it effective. So it wasn't valid. The two forward stock splits never validly occurred. But for years they had been acting as if it was, and they were out there issuing stock options, issuing restricted stock grants to people, and these with large zeros after it, not realizing that the company doesn't have that number of shares. And they did a whole bunch of other transactions. Once it got to us and we were engaged to represent them in reviewing their cap table, we realized they were in a huge mess because all of that wasn't done properly. They exceeded the authorized number of shares. We had to go back and fix it, which meant we had to go out to everyone that had been given options, been given stock, let them know that, oops, sorry, you received an option for 300,000 shares. Yeah, you really didn't get 300,000 shares. That never really happened properly. So what you actually got was something different. We're now going to go clean it up. And then once we cleaned it up, had to go back out to the stockholders and the option holders and tell them what actually now we're going to be getting once all the cleanup work had been done. It was a lot of work, a lot of time, and a lot of money, because it took a lot of legal time to correct the issues and go back and clean it up. So the resolution, expensive, took a lot of time. It was a big headache for everyone involved. The key takeaways, though, were if there was proper planning and guidance on the cap structure and changes that they wanted to make, the forward split, things of that nature, they wouldn't have had the mess that they had. It would have been much more efficient and effective for them to manage that if they'd gotten someone involved early on to properly guide them, including making sure that the proper filings got made with the Secretary of State, proper notices were filed, et cetera. And it would have been a tremendously lower spend than what they ended up spending to correct it. Okay. Let's talk about another issue that comes up a lot when startups get going, and you've got founders that get together sitting in a garage or coffee table talking about, hey, we've got a great idea, let's do this, let's work together. How should allocation of equity be distributed amongst founders, or even early employees or early consultants, when you get someone in that you need to help move this idea to, this concept to the next stage? It's something you really need to be thinking about. And I can't tell you how many times I've had clients come to me and say, hey, I started this company and I gave someone, 30%, and I've got the other 70%. They're not really doing what they said they were going to do. They haven't really put any money in, and I don't know what to do. So again, proper planning, thinking about all those what if scenarios, right? The most critical what if is the relationship going to work? What if it doesn't work? And what if this person that says they're going to do this or has this experience that they're going to contribute doesn't contribute it, doesn't provide the services? Oftentimes founders get together and they have synergies, right? Someone's a great finance person, someone's a great tech person, someone else has great contacts that can get doors opened. Those three are important pillars of what can be a successful startup. But if only two of them are working, and the one that's got sort of the business savvy and experience or operational experience isn't showing up, isn't doing what they're supposed to be doing, isn't there, doesn't attend meetings, well, if you've already had your discussion early on and you've already divvied up the stock three ways, they all equally, you've got someone with 30% of the company that's really not contributing, and it's just a big drag on the company going forward. So striking that right balance about how to allocate equity, think of it this way. Think of it as, if you're going to get married, you should want to know as much as you can about that person, right? Before you say I do. What are they like? What don't they like? What's their mentality? What's their philosophy or viewpoint on on religion or politics or money. I mean, are they good with finances? Are they not? Do they have a lot of debt, or do they not have a lot of debt? All of that sort of stuff are things that you should be talking about with your co-founders to make sure that you're all on the same page. And if there are any issues, iron them out, work them out before you sign the docs and start running at full speed with your startup. Because I've seen plenty of situations where that can become a problem and people end up ruining the relationship. The company falls apart. There's nothing worse at the very get-go of a startup than where you have founders that are in a dispute and not getting along. It just, everything flows down from the founders. So if they're not able to get along and they're not on the same page, the chance of the startup making it is really, really low. One way to approach it is think backwards when you're planning. So, think about where you want to be in 5 years, what that might look like, and then start working backwards about, thinking of ownership and control and dilution. How do you incentivize your team so that you're not caught off guard when suddenly, 3-4 years from now, you realize, oh, geez, I had 60% of the company, I've only got 30% now. And, I've got to allocate some more to my team because, they need to be incentivized and I really like them. I want them to stay. Do I have enough control? Do the founders have enough control versus, the control that maybe some investors have gotten? Think about all those issues and plan for it, because you don't want to be caught by surprise. And you want to make sure you've thought through those issues, before they actually come up. And of course, proper documentation. So the issue about having someone that, even a co-founder who doesn't participate and basically goes silent or ghosts you after a while, is the one way you can avoid that from happening, or at least minimize the damage that it can cause, is to have proper documentation, right? I mean, you'll hear me say this over and over again, proper documentation. So with regard to, equity grants, especially to founders and subsequently as well to employees and consultants, is make sure you've got in those documents, the type of restrictions on the stock that allow the company to buy back the stock if the person leaves. And I'm sure everyone's heard about vesting and repurchase rights and restricted stock. That's the mechanism that can be used, one, to keep people invested and incentivized to stay with the company, but also two, if they leave and they have invested in their stock or their options, then the company has resources and abilities to either buy back that stock, or for example, the unvested options will expire and no longer be available to exercise. But essentially that helps protect the company. So now you have people that may be walking away or leaving, but they're not going to take large chunks of equity away with them and then not be involved in helping the company grow. I had another client that had early on did everything themselves internally, had given a whole bunch of stock out, large percentages, 10, 15, 20% percentages to early co-founders. A couple of the co-founders just after a while decided they weren't interested in being involved in the company anymore and suddenly disappeared. They weren't involved, you couldn't get a hold of them, didn't want to attend meetings, weren't participating. And it left the company in a really bad situation because it had a lot of what we call dead equity, right? So we've got people that have equity in the company that are essentially not participating or going to make the company successful. So they're not helping, but yet they're large chunks of ownership. And it creates all sorts of issues on a going forward basis because they're not there to help with the company. You've got less of the company you can allocate out. If you're the active founder and you've got someone who walked away with 30%, every time you go to issue more grants, issue restricted stock, it's going to dilute everyone, right? But it's also going to dilute you, the active participating founder. It'll dilute the one who's not there, but they may not care anymore. So anyway, those are some of the things to be thinking about when you're talking about capitalization, ownership, how to allocate equity, just to have those conversations and those thoughts up front, so you're not surprised at a later date. Okay, so missteps for the unwary. Next topic that's oftentimes one that I talk about a lot is good corporate hygiene, good corporate record keeping. It comes in a lot of different flavors, but essentially it's just making sure you're keeping track of in managing the corporate records and the company records in a way that allows for you to properly protect the company, but also to make a lot of transactions a lot more efficient and cost effective and more successful. And I'll explain why in a few instances. But oftentimes, one of the first times, if you're not familiar with this issue, or if you don't have sort of a good mindset about good documentation already, the first time this issue comes up is when you go to do a financing. And now you've got an investor and the investor's attorneys who are going to turn over the rock, every rock, and look for issues and problems, because what they're trying to do is protect their clients and their clients' investment in the company. And the best way to do that is to really understand what they're getting into, right? It's the proverbial kicking the tires of the car, before you buy it. You look under the hood, you look all around, you check out the engine, you check out the tires, you check out everything else you can, so you know exactly what it is you're buying, because the last thing you want is you hand the check over, you drive off the lot, and then, something happens, the wheels come off and you crash. Not a good situation to be in. So this comes up during diligence when the company's, is having to answer a lot of questions, provide documents to the investor and its counsel. And it's a deep dive oftentimes into the company. And if you're not prepared, don't have good documentation, don't have good record keeping, I won't say it will, necessarily kill the deal, although I've seen it kill deals before, but it just creates a bad situation. Now you've got the investor thinking, well, maybe you don't really know how to run the company properly. You're not really organized. You're not very effective in managing the company. But also, if you're not keeping good documentation, things can slip through the cracks that may come up to become problems later on. A couple of examples: you may have some really important contracts with a customer and you're not keeping track of them and didn't realize that they terminated because they were a one-year contract. You signed them in February of 2020, and 2021 rolls around, they weren't renewed, they've terminated. Now you may still be working with that customer, but if there was an issue that came up, the customer may look at it and say, well, geez, we're not going to go with you anymore. Our contract expired. We're going to go look for something else. Not a good scenario to be in. We talked about problems with capitalization. If you're not managing the cap table properly, that can be an issue if you don't have good, proper documentation. If you haven't filed, when you go to sell shares, securities, you have to file for certain exemptions. Those can be problematic if you have an investor looking and you haven't done that properly. All sorts of things can come up if you're not keeping good, proper documentation. For example, and I have this on the slide, is certain actions need to be approved by shareholders. Certain actions need to be approved by the board of the company. And if those approvals aren't obtained, you can potentially have a scenario where the action that the board, the action the company took wasn't a valid action. And that can create issues, for example, on diligence with an investor, or it could create issues where, in a subsequent transaction, you want to sell more shares and you need the law firm that's representing you to provide a legal opinion. Legal opinions are a very entailed process that involves the law firm providing opinion that certain things are, consistent with the laws, et cetera. And if you don't have proper corporate actions, it may be hard for that law firm to give an opinion, and the investor may say, look, I'm not going to do the deal unless you give me an opinion. Or if you can't give me an opinion, that can raise red flags in and of itself. Other actions can just not be effective. So if you remember the story I told you about the company that didn't properly manage the cap table and thought it had done a bunch of stock splits, well, the board hadn't properly approved it. The shareholders, hadn't properly approved it. They didn't file it with the Secretary of State. So that was an invalid action that they took. Then they went out and sold a bunch of stock and granted stock options. Those were all defective. That's where sometimes those issues can come up. Some of those problems can be fixed, after the fact, but you just don't want to ever be in a situation where you have to do that. Better to get it done early on than not. Okay, so here's another topic that comes up a lot. Just checking on time. Waking the sleeping devil, as I like to refer to it. Stock, issuing stock, granting stock options, how do you price them? What do you determine to be the price on those? That's a whole area where oftentimes it is a sleeping devil. And a lot of companies misstep on that process because they just assume, hey, I'm an early startup. I don't have sales yet. I don't have a customer. So my stock's really not worth anything, right? So I can just go out and kind of set an arbitrary price. I'm going to make it really low. I'm going to go give a bunch of options. I'm going to go grant a bunch of stock. And, when I get revenue coming in or I've got some significant assets, then I can kind of figure out, what the stock's really worth. Well, the problem with that is, especially with regard to stock options, if you have if you're going to have a equity incentive plan or a stock option plan, and you want to grant options to employees or consultants, or even to founders, it's got to be done properly. If you don't do it properly, you can have all sorts of tax and issues and penalties and things that can accrue, and problems that'll come up later on. They may come up primarily in diligence, either if you're doing a financing, or in some cases, you've gotten far enough along the path, the devil has been sleeping for years, and then suddenly it comes time to sell the company. And now you've got the buyer's counsel doing their diligence, and they somehow uncover this. The devil is awoken, and now you've got a scenario where you've granted over the last 4 or 5 years a whole bunch of options. You didn't price them properly, and now there's some tax consequences. And you've got to deal with that before you close your transaction, and that can come at a pretty hefty cost. So there are all sorts of rules. I'm not going to get into the details of it, but if you're going to be granting options and you have a plan, then you really should have a 409A valuation. And essentially that 409A refers to the IRS code section that governs it. But it's to come up with a fair market value of the option, the exercise price for the option. And you need to issue or grant your options at a fair market value. And if you don't, then there can be all sorts of tax consequences. So if you give someone an option, at a really, really low price, let's say you give it to them for a penny a share, but the actual fair market value is $1 a share, that's 99 cents of some potential taxable issue that's going to come up at some point. And it can incur penalties and interest and all sorts of issues if it's not dealt with properly. So getting the valuation done, getting it done, at the right time when you're going to be going out and issuing options is really critical. And I can't tell you how many times I've seen companies don't do that because they're either worried about, or they don't know about it, or they're worried about spending the money to get the proper valuation to be able to go out and issue options. And there's all sorts of ways to approach it. If the company really doesn't have the funds, then you may want to take a different approach. Instead of, having an option plan and granting options early on, you may want to grant restricted stock, or there's other types of potential things that you could do to incentivize people to work with you, employees and consultants, without having to actually issue options or having to issue a type of security that needs to be issued at fair market value. So that's where you really need to get a professional involved. You get your attorney involved. Oftentimes it's your tax advisor or the tax attorney that can help structure it in a way where you're complying with the requirements and the laws and not creating some sort of potential tax issue down the road. So one example that this came up in an M&A transaction was the company had been around for a long time, got to a point where there was a buyer. It was a pretty large transaction. Company, because it had been around so long, had issued a whole bunch of options. And in its early days, it hadn't priced them properly. It priced them, much lower than they actually should have been priced. So when the attorneys for the buyer started doing their diligence, they uncovered this issue. And then it was kind of a mad scramble to figure out how to deal with it. And so essentially what had to happen is had to calculate out what all of the taxes and penalties and everything would be for not having priced the options properly, figure out that amount per individual option holder that hadn't gotten the options priced properly. And essentially they had to be cashed out in that amount so that they could go ahead and pay and make sure that they could pay those taxes. So what it meant was taking a pretty significant amount of the proceeds from the M&A transaction and having to allocate some of that to clean up that mess by grossing up and paying out some of those option holders in an amount more than they otherwise would have received but it was because it was really the company's responsibility to make sure that it was issuing them at the right price. And because it didn't do that, it ended up getting stuck with the tab and having to compensate for that. So that was, it was a pretty significant amount that otherwise could have gone to, people that were supposed to be receiving, all the proceeds from the transaction. Okay, so let me, we got about 20 minutes left, so let me go through some of the other examples as well. Okay, so another area where I see mistakes made with startups is where there's sort of a mismanagement of contracts. I touched a little bit on this, so I'm not going to spend too much time on it, but it's really not keeping track of your documents, your agreements, or important terms. And it doesn't seem all that important initially, but it'll become more and more important as the company grows and starts to sign more and more documents, more and more agreements. Some agreements you sign, you put on a shelf, and you probably never look at them or read them again. Other agreements you're going to sign, and you're going to need to keep track of them because you need to know if there's any particular issues that come up. Do you need to go back to that other party that you signed the agreement with, whether it's to get an approval, whether to provide notice, or whether to extend the term? The best example, which I think everyone will understand, is if you take on a loan and you go to a financial institution, oftentimes the loan agreement will have a whole bunch of provisions in them. It'll have things that you have to do, things that you can't do, things that you need to notify the bank about if they happen. And you need to at least keep track of that somehow, at least know that that's there, so that then if you go and do another transaction, or you want to go and buy another company or do something that might trigger providing notice to the bank or letting the bank know or getting the bank's approval, that you're aware of it so you can go out and get those approvals. Because if you don't get the approval, that could potentially be deemed a default under your loan agreement. And now you've got a scenario where you did a transaction that your lender was supposed to approve, and they didn't approve it. They find out about it. They're not happy. They call a default on your loan, and you don't have enough money to be able to pay off the loan. Now you're stuck negotiating with them on how to correct the default so you can keep the loan in place. I mean, it can be an ugly situation. Oftentimes it'll get worked out, but in some cases, if you can't work it out, you end up spending a lot more money to try to battle it out, and you just don't want to be in that kind of a situation. Okay. Another area that is super important, especially for startups, especially early stage, is making sure you're protecting the crown jewels, right? I mean, a lot of companies, especially being in Silicon Valley, San Francisco area, other parts of the country and the world, oftentimes a lot of startups are really dependent upon their core technology. And it's oftentimes something, whether it's software or it's an AI type technology that's being developed, or it could be a platform, whatever the case may be. It's who's developing it, and who has the rights to what technology is being developed for the company. And you want to make sure, as for the company should be the one to own that. Generally speaking, you want the company to own it, because if that's the company's business, and you as a founder, or maybe the company's gone out and hired a key software engineer or developer to come in and build the technology or help develop the technology, keep in mind that absent some sort of agreement, a lot of laws, whether it's the state laws or in other countries, it may be different, but the person that develops something oftentimes has some sort of rights to what they've developed. So good example is with a patent, right? If I invent something and I get a patent on it, I'm the inventor. I own that patent, and I'll have certain rights in connection with that patent and the technology that it covers. So if a startup then is created and it relies upon that technology, it really should be transferred to the company. So the company is the owner of that patent. And then I, as the inventor, should be signing off, making sure that I've properly assigned my rights to the invention and the patent to the company, so that there's no issues with me having any ownership. So that, as you remember in one of the prior examples, a founder walking away after a few months and not wanting to be involved, if I were to walk away after a few months and I never signed the proper documentation, then I walk away with ownership of what may be a critical piece of technology the company can't survive without, or won't be able to do what it wants to do without. And then, fast forward, you go to talk to an investor and they're doing their diligence and they say, okay, great. Well, we like this technology you've developed. It's really great. We think it's really going to be valuable. We looked at the patents and, who's this Ali Dadvakili guy? Looks like he was an inventor. And then they're going to be looking for the document that says, I, Ali Dadvakili, have assigned over all my rights to that patent to the company. And if they can't find it and you don't have it, well, one of two things is going to happen. You're going to have to then go and find me and negotiate with me to sign it over. And unless I've signed something else with the company where I'm bound to sign it over, there's nothing requiring me to sign it over. And then it becomes a very difficult negotiation, because the company has very little leverage over me, whereas I can say, well, great, I've done a little research. I think it's really valuable. I think I want $1 million. And then you're stuck. It's like, if you don't have any other ways to get it and you really need it, you're going to be in a bind. So that's the big mistake I've seen happen before. The way to avoid it is just make sure you've got the good documentation up front. So as a founder, employees, consultants, anyone who could contribute to the technology, the IP, something of value that the company may have. It doesn't have to be something really fancy or technical. It could be you bring someone in who's got, really good sales and marketing, and they're going to be creating from scratch a whole bunch of materials for you, including a very customized customer list, really specific and customized marketing materials and information that is not stuff you could pull down off the shelf or Google somewhere. All of that's proprietary as well. So even those types of folks should be signing documentation that makes sure that whatever is being created for the company is owned by the company. And it's in a lot of standard, we see a lot of that kind of standard language. It's referred to as an IP assignment agreement that should be put into place very early on. And for the reasons I've explained, if you don't have it in place, you're asking for some real potential problems. One example was early on, a client had hired someone as a developer to come in and develop some technology. It was website based, and they did a really nice job. The website looked great. The features that they did looked fantastic, but the company had signed the agreement that the consultant had brought to them. And in the fine print, the devil's in the details, they didn't realize that the developer actually owned all the rights to what he had developed for the company. Wasn't transferred over, it wasn't owned by the company. So essentially they had to keep using him and his company for management and hosting and all that sort of stuff. And if they ever wanted to terminate, he could turn around and say, well, look, I own everything. So if you don't want to use me, great, I'll unplug it and your website's going to go down. You can go create something from scratch. Big problem. They were able to work it out, but it was a lot more time consuming and stressful and costly to work it out than if they had the right agreement in the beginning. Okay. So what do? You negotiate, you try to make sure you get the stuff up front. If you can't, then you have to try. The resolution is you got to settle with those folks and get what the company needs to move forward. So key takeaways, especially when it comes to crown jewels, if you will, or IP for the company, make sure you document your rights. Couple more acronyms. I saw one comment in the chat about a lot of acronyms. So there are a couple of different agreements, or different acronyms mean the same thing. CIIAA or PIIAA. Really, what it means is confidential information invention assignment agreement, or proprietary information invention assignment agreement. Those are key agreements. Founders, employees, consultants, we would typically expect all of them to sign some sort of agreement like that. And that's the agreement where I mentioned that not only does it have the confidentiality piece, but it also has the piece that if they develop something for the company, it belongs to the company. Those can be complicated. Oftentimes it's state specific if I'm talking about the US. So you have to make sure you understand the specific state where that person is working or residing, or what jurisdiction will apply, and make sure that you've got the right language. I've seen plenty of times when, a founder had another company that was successful in the past. They used a lot of the same documents from that company for their new company. but they actually moved, they were in Florida and then they moved to California, and they used the documents they had that were done appropriately by a law firm for Florida business, but they were using it for California. The problem is California has very different laws when it comes to, what is proprietary and what is not. There's specific labor code sections in California that govern when something is created. Does it belong to the employee or does it belong to the company? And so if you're not creating a document that's going to be complying with the law, which will govern if there's a dispute, you're asking for trouble, because you may have someone sign it, you think everything's fine, you use an agreement you used previously, let's say the Florida company agreement, now you're in California, the person leaves and there's a dispute, then you go to enforce the agreement, you realize, oh shoot, I'm in front of the doorsteps of the courthouse and the court's telling me this agreement is not enforceable in California. Not a good situation to be in. So that's where a good legal advisor can certainly help you, and especially in this area, because it is very state specific in a lot of cases. Okay, so now, and we think we've got about 9 minutes or so left before we open up for Q&A. So let me talk a little bit about preparing for your first deal. And I'm assuming that your first deal is really going to be like a financing. Your first deal could also be your first commercial agreement, your first customer agreement that you have. So it doesn't have to necessarily apply to just your first financing, but oftentimes that's what a lot of startups are focused on. So I'll use that as an example. I know there's been a recurring theme throughout today's discussion about preparation, organization, and it just goes without saying, especially for your first deal, making sure you're organized and you have done enough homework to understand not only what state your documents and your company structure and capitalization, everything is in, but also understanding the other side, the other party to this transaction. And if it's going to be an investor, understanding your investor, doing your homework and diligence on your investor, and trying to anticipate. It's the what if, or the, asking the 5 questions: who, what, when, why, how. What is the investor going to be looking for? What are they going to be asking for? What should I be anticipating? And those are easy to come across. I mean, you can talk to your friends. If you've been in deals before, you'll know. Your friends may know. I mean, certainly you can call, your lawyer and get legal advice. They'll certainly know, and they can give you that guidance. And once you kind of know what the investor is looking for, the kind of things they're going to be asking for, then you've got sort of the parameters of what you should be doing to prepare. Organize your documents, make sure they're organized in a way it's going to be easy for people to go through them, read them, understand them. Maybe even set up a data room. Even if you don't have a deal, even if you don't even have a term sheet yet, doesn't mean you can't get super organized, so that when you do have a term sheet and it's signed that very same day, you are so ready that you can basically turn on the data room, give them access. Your documents are in fantastic shape, and if nothing else, you'll make the deal go a lot smoother, potentially a lot quicker, potentially less expensive, and probably impress the hell out of the investor, because I can't tell you how many times that's not the case, where you sign a deal and then it's a mad scramble to, oh shoot, now we got to get everything ready to go, talk to the investors and answer their questions. Use your advisors efficiently, do your homework, study. You should be familiar or learning as much as you possibly can about what it is you're asking your lawyer to help you with. What that'll allow you to do is it's going to allow you to ask more intelligent questions, ask, where you can be most helpful. And it'll just allow you and your legal advisors, whether it's your attorney or whether it's your tax advisor or other advisors helping you, it'll allow you to be able to be on the same page. You'll have more synergy, because you'll know the sort of things that are important to them. They'll know what the homework you've done and how you prepared to be able to answer questions and to get up to speed quickly. And it'll allow the process to go through and flow a lot more efficiently. Okay, so the last example, and I've got enough time to cover it. So this is one that I kind of saved for last, because it's one that I experienced many years ago, and it was a small little company. They were doing really well. They had about 1-2 million or so in sales a year. They developed a really cool snack food. It was like a snack bar. And they had that process down. It was a particular way that they would create their snack bar was kind of ruled with oats and granola and things like that. They went to a trade show. They were approached by a distributor from another country. And, the distributor had a base here, and that distributor was shopping for new products, for new types of bars for their customer. And they really liked what this client was doing. So they approached the client and said, look, we want you to create a new type of bar. Instead of what you've been doing, we want you to, it's going to be baked. So different process entirely. But we know, you created some incredible tasting bars here, so we think you can do it. So they had some early discussions. They had an oral agreement, and the distributor actually fronted costs to the company so that they could go out and buy some additional equipment. They needed ovens, they needed mixers, they needed things that they didn't have because they didn't need it with the existing bars that they were creating. So anyway, they did all that. And then they finally got around to saying, oh yeah, we should have an agreement, right? Yeah, okay, let's call the lawyers. And so the company called me, scheduled a meeting. I didn't really know what all we were talking about other than, hey, we want to have a meeting with you. Can we meet on Tuesday at 3:00? Great. So we had the conference room. They introduced me to the distributor. They gave me a little bit of the background. And then they start talking about the deal. And as I said at the last bullet point there, disaster ensued. So it wasn't too long into that meeting that I realized, oh my God, these guys have not had any of the discussions about how to properly document this deal. They hadn't talked about much of anything. And it was shocking because they hadn't even figured out what the company's cost was to manufacture the bar and sell it to the distributor. Yet they had been talking to the distributor about how much they were going to sell the bars for. So when I started hearing that, I stopped the meeting. I pulled the client aside and I said, look, guys, you guys are talking about, do you realize you just have told us in this meeting that, and I'm making this up now, but it's costing you 30 cents to manufacture a bar. But you've already told the distributor you're going to sell it to him for 20 cents. How are you going to do that? And it was 500,000 bars as sort of the first trial run. And then if that went well, they were going to order, 1 million, and then it was going to go up from there. You guys can't do this. It's not sustainable. You're going to lose a ton of money on this, and it's not going to work. So after finally talking to them about that and getting the focus on all of those issues, basically the agreement got scrapped. They couldn't deliver it. It was not going to work financially. They were having problems with manufacturing the bar, baking the bar properly. So essentially the deal fell apart. They had to return the equipment. They couldn't return the equipment. They had to pay the advances back. They lost that potential sales. They lost any future sales. It was a disaster. So had they done their homework, figured it out, they probably, I'm sure, could have negotiated a price that would have made it profitable and spent the time to figure out how to do the baked good versus what they were already doing. Okay, so I think we have a couple more minutes. Resolution, they just couldn't deliver. They lost the sales. It was a huge blow for the company. So parting thoughts, and then we can open it up for Q&A, is, again, doing your homework, really know what you're getting into. The one thing I didn't talk about too much, but it was sort of discussed indirectly, is any kind of agreement the company is going to enter into, whether it's a financing, it's a customer agreement, an employment agreement, one of those CIIAA agreements, is what you're trying to do with an agreement is essentially take a relationship and encapsulate that relationship in writing. So you've got something in writing that can capture the relationship and also help govern that relationship on a going forward basis. So when you think about it sort of from a philosophical standpoint, it's a really difficult thing to do, right? You're taking something that's very fluid, and trying to put something in writing that's going to capture all of the different what if scenarios, or as many as you can. You can never capture all of them. Protect both sides, make it fair, make it easy to read and understand, so that there's a higher chance of success going forward. Everyone knows what they're agreeing to. There's alignment. There's processes in place in the agreement if things go awry or if there's issues or disputes. That's really the goal of the game when you're documenting a transaction. And so with all of that said, you can't do that effectively unless you have spent the time to really understand the business, understand what it is that's going on with the company in order to get to that point. So let me stop there and want to open it up to questions and comments. I've got my name there and my email. You're welcome to reach out to me if you have questions or things that I didn't answer on the call, or you want to have more discussions about. Feel free to reach out, and I'd be happy to chat with you. So I'm going to go through now and look quickly at some of the questions. Okay. Yeah, so this is being recorded. I will send around, I'll follow up with an email probably in a few days from now. There'll be a link to the recording. So you'll have that. If you weren't able to attend it or couldn't attend all of it, you'll certainly have the ability to listen to the recording. I think we also are posting them up on YouTube, so you'll be able to get it there as well. Okay. So LOI, MOU, I think I answered that. Letter of intent, memorandum of understanding. It's like a term sheet. What kind of term sheet can be used with a broker dealer? That's a really specific question. If you're using I'm not sure what the broker dealer would be used for other than potentially going out and raising financing. I'm assuming you just have to be very careful if you're doing that. You need to make sure you're talking to a very reputable broker dealer that has all the licenses in place to be able to act as a broker dealer. It's a very heavily regulated area, and a lot of people will try to get you to work with them, saying, "Oh, I can help you find financing. I've got a ton of contacts. I can get money for you." If they're not properly licensed, then they're going to run afoul of the securities laws, and they can get into trouble. But certainly, it's not good for the company to be using someone who's violating potentially the securities laws and trying to raise financing in a way that's not following those securities regulations. With very early stage startups, I don't see a lot of folks using broker dealers. Doesn't mean there might not be a scenario where it would make sense, but just make sure it's a very reputable company and that they've got all the licenses in place to do what they say they're doing. Another acronym, I didn't say what it was. It's on the slides. It's a COI. That means Certificate of Incorporation. That's the document you file with the Secretary of State to form your company. It's your charter, if you will. So early on, when you first set up your company, it'll be very simple. It'll indicate what shares are authorized, the type of shares, et cetera. As you go farther down, and if you're going to go out and sell preferred stock, it'll be more complicated. It'll have preferred shares that'll be identified. It'll indicate what the rights, the preferences, powers of those particular shares are, voting rights, things like that. Okay, so here's let's see. So this is a question. I'm from England, started a startup having interest in nanotechnology prototype development, and any help, including to avoid failures from funding to scale ups. Well, I think everything I touched on is highly relevant in this case too. This is all technology industry agnostic. There will be additional layers. If you're in a particular industry that's highly regulated, then obviously you need to make sure you understand what those regulations are and that you're also complying with those regulations. So for example, if you're dealing with something in the health area, life sciences, if it's a health tech type device you're developing, then there's going to be additional regulatory issues you need to be aware of. If you're in a company that's going to be developing something that's relating to fintech, like transfer, financial transfer transactions, things of that nature, that's also heavily regulated. So again, I can't overemphasize the need to get good counsel involved, because as those get more and more specialized, or more and more regulations govern specific areas or specific industries, having someone that understands those is going to be super critical to making sure you navigate them without making big mistakes. Okay, let's see. Okay, long-term. I didn't quite understand this. So this is looks like okay, never mind. That was just something looking for some help on that. Okay, question about subscription agreements when there's an opportunity. Okay, so what is a subscription agreement? A subscription agreement is also referred to as a stock purchase agreement, oftentimes used when you're setting up the company and you've got the founders that are buying an interest in the company, it really essentially does the same thing. It's the purchase of the securities in the company. So if you have a couple of founders getting together and you're forming your company, you oftentimes might refer to that agreement where the founder buys stock in the company as a subscription agreement. It could also be, and oftentimes is, referred to as a stock purchase agreement. So they're really the same thing. It's the purchase of usually securities in the company. Okay, I'm an angel investor, emerging tech. Okay, so that's someone that does investing. Okay, so apologies for using acronyms. Costs associated with 409A valuation. So I did talk about 409A valuations, and 409A is, as I mentioned, is the reference to the specific code section in the IRS that talks about making sure you're properly valuing the options that are being granted. There are a lot of companies that can provide 409A valuations. They come in a whole wide range of prices. I mean, I've seen anywhere from a couple $1,000s on the very inexpensive end to 6, 7, 8, 10 or more thousand on the higher end. I will tell you this though, and there are some companies that are doing that on the lower end, recognizing that they work with a lot of startups. I'll give you one example. There's a company by the name of Carta. Many of you may be familiar with it. It used to be called eShares. It's a cap table management program. We use it a lot. We have a lot of clients that use it. A lot of investors like that program because once you've onboarded everything to the program, it allows you to very easily manage your cap table. And it allows you to issue certificates and grant options without having to print documents or anything like that. So it's a great way to manage your cap table. It's subscription based. So oftentimes you'll pay an annual subscription fee for the services. And they've got different types of packages. One of the packages they have is they will do a 409A valuation for you. And you got to buy a certain level package to be able to get that included. But once you do, then it's included in that package. And then when you need to get a 409A valuation, you can have them run it. And because their company is their platform is managing your cap table, it makes it very easy for them to go in and do that type of evaluation. So costs, I think I answered anywhere from 2 in the low end, could be 8 or more on the high end. But I would certainly encourage you to look at Carta. There may be other companies out there that offer similar type programs where they bundle sort of cap table program management with 409A. I don't know of any others other than Carta. And in the interest of full disclosure, we use Carta a lot. We offer our clients a discount because we have such a large volume. Not that I'm pushing Carta, but you'll see a lot of investors like Carta as well. But there are other companies that you could use, and they may also have a 409A type valuation service as well. Okay, so 409A, I think I mentioned what it was for startups. Happy to answer or go into a little bit more detail if anyone wants to reach out to me after this presentation. Okay, so here's a question. What if you had a patent before you started hiring co-founders? Would you reassign the patent rights to the company? So if I understood the question, it's you had a patent that you invented before you started the company, and then you started the company and we're going to add on some co-founders. Should you then transfer or sign your patent rights to the company? The answer will depend. If the patent that you developed on your own before you founded the company relates to the business that the company is going to do, or relates to the technology the company is going to develop and commercialize, then yes, I would think it would make sense because you've developed it, you've created it. If the company can use it and that'll help the company move forward, then yes, typically you would assign that patent over to the company and then the company would own it. In some instances, I've seen scenarios where, the founder or the inventor doesn't want to assign it, they want to license it and then have some revenue stream that comes back. I mean, in very rare circumstances that might work, but if the company's going to go out and raise financing from outside investors, that strategy is not going to work because the investors are not going to want to have their money tied up in a company that doesn't own the actual technology that is going to make the company successful. They're not going to want to have to rely on a license agreement. And what happens if the license somehow terminates or expires or something happens? then that just creates a lot of risk. So typically not something that investors are going to like. Okay. Who reviews the verbiage of documents to make sure they are legal? Do you need a lawyer to review this? Yes. So typically, if you're looking at, whether if it's an agreement, a legal agreement, so, buying shares in a company or selling shares in a company, an employment agreement, it could be the confidentiality agreement I mentioned, your financing documents, if you're raising financing, a joint venture agreement, all of those types of agreements, or any agreement for that matter, the best person, or the person in the best position to review it and make sure that you're getting good advice on how to properly structure it, how to properly negotiate it, is really going to be a lawyer. And you want to make sure if it's a corporate agreement, you go to a corporate attorney. If it's like a commercial agreement, a lot of corporate attorneys will do commercial agreements, but you just want to make sure that they've got experience with that specific type of agreement, because every agreement is different. Different types of agreements will have different types of provisions, and you want to make sure that your legal advisor is familiar with those types of agreements, because then they'll know the issues, they'll know that, where things can go wrong, the types of provisions that are market or not market, common, not common, and can best advise you that way. Okay. Do you happen to have a list of questions for the investors that we must ask? I don't know that there's any must-ask questions. Think of it this way. If you're going to take on an investment, whether it's an individual angel or it's a VC group, you're creating a relationship. And so I would want, if I was in the position of being a founder looking to take on an investor, I would want to make sure I'm asking questions and getting to know the investor on a personal level. What's important to this investor? If it's an individual, what's important to them? What sort of things do they invest in? If it's a VC firm, what's their area of expertise? Do they have an area of expertise? What sort of funds have they invested in? What sort of companies have they invested in? What's their process for investing? Do they invest in early stage, mid stage, late stage, all the above? Do they usually invest in a way where they will put in an initial investment and then anticipate investing in subsequent rounds? So you've got an investor that might be with you for the long haul, as you continue to go out and raise financing, or are they kind of a one shot? They'll do an initial investment, but typically don't get involved in subsequent raises. Those are sorts of things that I would certainly ask. If it's a VC firm or a VC company, ask about, how many funds they have, where they are in the life cycle of the fund that they think might be investing. Is it sort of in the beginning? Is it in the tail end? Are they anticipating any additional funds? If they've invested in other similar type companies, that's oftentimes helpful because they may know your space really, really well and can provide very smart money, if you will, where they've seen things happen. We talked about a lot of big mistakes that can happen with startups, primarily from the legal perspective, right? But they may have all sorts of ideas and thoughts on how to avoid big mistakes that they see from, maybe it's an operational standpoint, maybe it's from the investing standpoint, or other areas of expertise they can bring to the table that'll be very helpful. Another question, can a founder ask if our relationship does not work out, how do we handle this situation? I was told to only accept investments from investors that you will keep and have a good relationship with. Good question. As I just said, it's the most value. I mean, obviously the money is going to be extremely valuable, but beyond that, if you're looking at a sophisticated investor, not necessarily just sort of family and friends that are putting in money to get you started, but you really want a good relationship. You want to make sure you've got a good relationship because they have experience and knowledge that could be really helpful. I mean, think about in all of your respective lives, I'm sure there's been mentors you've had or people that have been really important guides at all stages of your life where, you got a tremendous amount of help from someone because they had been through something before. And then when you were going through that same thing, they were there for you. They guided you. They got you through the rough patches. And the investor can be very much the same, can play the same role. And I've seen that play out in board meetings where you've got investors sitting on the board and a really tough issue comes up. The CEO doesn't know how to handle it, but one of the board members said, oh yeah, we just dealt with that issue with one of our other portfolio companies, and here's what happened, and here's how we got through it, and here's what we ended up doing. And it's like, oh, aha moment. Wow, that's great. Now I at least have the experience of that person telling me how I can get through this rough patch. If a relationship, so can a founder ask if our relationship does not work out, how do we handle this? I'm not sure I quite understand. I think what you're asking about is how do you handle a relationship with a founder if it, co-founders, if it doesn't work out amongst the co-founders. Well, that's where I think you go back to the basic building blocks that I was talking about throughout is making sure you've had those difficult conversations up front. So with regard to founders, if you're going to come together to create a company, the kind of discussions you should be thinking about or having, and there should be no topics that are not appropriate, but it's, work ethic, commitment to, being involved. What are you contributing? Are you contributing money? Are you contributing experience? Are you contributing IP? Are you contributing contacts? How many hours are you going to be working? How many, do you expect to take off 6 weeks for vacation? Do you anticipate, selling out of your interest in a couple of years? Are you in for the long haul? Is this really an area you're passionate about? Or are you just doing this because you don't have anything else to do and you just want something to do? All of those questions and whatever other questions you can think about to get to know this co-founder. And even if you know them well, even if they're a friend, I would press on some of those issues. There may be issues that maybe as a friend you weren't comfortable talking about, but as a co-founder you should. So other examples might be, if they're married, do they have, should their agreements for the company have something so that if there's a divorce or a death or disability, what happens? So if you're 50-50 owners, that can be a precarious situation. If one of the 50% owners, let's say, gets hit by a car and is in the hospital for 6 weeks, the company, if it's at the board level and you're both the board directors, can't make decisions. I mean, it's going to be tough. If you needed his vote, how do you make a decision? If maybe he was the only one that was on the bank account, how are you going to be able to access the bank account? So think about all those scenarios, the what ifs, right? What if a co-founder gets divorced, gets disabled, dies, retires? Those are sort of the 4 big ones that you want to cover. And then knowing how each party feels about that, you can then go to your lawyer and say, look, here's what we want to do. We want to have, as an example, if someone wants to leave the company, we want the company to have the first right of refusal to buy that person out. Or if they were to die, oftentimes there'll be a scenario where the 2 people are so critical, you will put in place key man life insurance so that if something happens to one of them, there'll be enough cash coming in from the life insurance policy to either cover the company for a short period of time or to go and find a replacement to bring someone in to be able to help run the company. So all those are types of conversations you'd want to be discussing. Okay. Yeah, someone mentioned in response to that question that I just read out was a code of ethics. Yeah, I mean, obviously, understanding each person's sort of ethical disposition and philosophy is important too. There can be conflicts of interest or, ethics codes the company could adopt. Someone said they have a question they want to ask verbally. Just reach out. We'll set a time to set up a call. No issues. So my partner is in Canada and I'm in the US. Does it matter where our agreement is created? Well, great question. So it does. I would say, where is the company going to be located? If the company is going to be based in, for example, the US, and that's where you anticipate the company will be able to grow and scale and basically go to market or whatever the case may be, then you probably want to have the agreement in the US governed by US laws. Because if there's a scenario, and as you grow, if you add more people on, trying to centralize that and standardize that, so you have all of your agreements governed by the same law, the same state jurisdiction, if you will, it makes it a little bit easier from a management standpoint. But then whatever agreement you create, if you create an agreement here in the US, if your co-founders in Canada, they should then go to talk to their lawyer and make sure that is there any issues under Canadian law that's going to potentially impact this agreement? Is there any issues that maybe needs to be changed so that it's not violating some Canadian law or that it complies with Canadian law as well? So that would be an important part of the diligence to make sure it's done properly. Who reviews what is acceptable and legal on code of ethics documentation? So Not quite sure what you mean by code of ethics documentation. If you're talking about sort of a code of ethics for the company, or like a conflict of interest policy for the company, oftentimes lawyers can help with that. We do that from time to time for various companies that do want to have those sorts of policies and procedures. So that would be something I would reach out to a lawyer for. Okay, so here's a question. We've got about 10 minutes. Was a consultant to a company that had a habit of giving out subscription agreements to consultants and advisors as comp. However, once they stopped seeing the value in work, they would issue a cancellation of the subscription agreement. My take is the subscription agreement is still valid and that the advisors and consultants would still have a claim to shares. Well, always hard to talk about an issue if you don't see the agreement, right? Because the devil's in the details. So you really have to see what the agreement says. But just from a general standpoint, and the kind of agreements I talked about earlier on that you'd have with employees and consultants that are working for the company, if you give them options or you give them stock, you would want to have in those agreements provisions that provide for vesting of the stock they get, and provisions that they can't transfer the stock unless they're it's in compliance with securities laws, or maybe before they transfer it, the company gets the right to buy it before they can transfer it. But if they leave, the stock that's not vested can get repurchased by the company at the same price they paid for it. That's one oftentimes helpful feature to have in your agreement, so that they can't just walk away with a bunch of stock. Or even you could have a right to repurchase stock that's vested, at maybe fair market value. A little bit less common that I see that. But yeah, the agreement itself doesn't necessarily get canceled or terminated. So what would happen though is if it's drafted properly, the agreement would still continue on. It's what happens to the stock once the person leaves. Can the stock be repurchased by the company? Is there a vesting schedule? And have they vested in the stock? They could, can they walk away with stock that's vested and hold on to that, but the unvested stock gets repurchased by the company? That's typically the way I see it. It doesn't sound like just canceling the agreement makes sense, because if they've given them the stock, and even if you cancel the agreement, they've got the stock, they've received it. So you can't just go take the stock back just because you don't like the person anymore because they're not working hard or not working for the company, unless it's drafted in a way that gives the company the right to repurchase the stock if the person leaves, upon the conditions set out in the agreement. So here's a question. Would you have someone in UK as partnering and helping with startup tech product developments? Actually, we have a UK office. We have a quite large office in London. We do a lot of work with startups and companies in the UK as well as other parts of the world. So if you need help involving anything in the UK, certainly feel free to reach out. We will be distributing the video afterwards. Should you have consultants such as branding, strategy, etc., folks sign NDA agreements? I think as a matter of course, it's good to have anyone doing anything for the company sign an NDA. I mean, there may be an off circumstance where the person is just coming in, they're not providing anything confidential, they're not accessing any confidential, they're not going to have anything that would be sensitive or confidential. Maybe in that case, no. But my usual philosophy is get everyone to sign one, because you never know, right? People, especially with startups, people might start even as a receptionist, and then they're there for a while, they get to know the company, they're really good at what they do, and they've got the potential to grow, and then suddenly they get promoted. Now they're the manager of the office, or they're now helping out with HR issues, and now they're accessing and getting information that as a receptionist you may not be too worried about, but as someone managing the office or being involved in HR or being involved with product development or sales, obviously could be more sensitive. And even the receptionist, to the extent they're going to be having access to emails coming in, or people coming in, they could be an executive assistant that gets access to certain things for the executives. There could be sensitive information in that. So it doesn't hurt to have it in place, and in fact it would help. And then you don't have to worry about promotions or changes in job titles or responsibilities over the years. You've got one in place, and that'll govern that person's relationship with the company. Let me see if there's any other. Great. So I saw some chats about the name Carta and then the website to go to. How to find real ETO equity token help in the US. That I'm not quite sure about. Happy to chat with you offline if you want to send an email or give me a call. Okay. To avoid idea theft, what kind of documentation should I send to potential investors? The whole business plan or something much smaller? If so, what documents concerning the company's IP do investors want? Great question, and I'm really glad you asked that. Something I didn't cover, but which is very important, is investors. Your typical investors. If you're talking to a sophisticated sort of institutional investor or a venture capital firm, they will almost never sign a confidentiality agreement. And if they're a reputable VC firm, don't push that issue because it's only going to ruffle feathers. If they're reputable, they just know they're going to be, getting a business plan, they're going to get access to information, and they'll ruin their reputation if they go out and either steal ideas or do something they're not supposed to be doing with it. So, by far and large, not something you're going to be able to get from that type of investor. But with regard to what you should disclose, general business plans. We call them business plans. They're called slide decks now, or they're shorter, more capsulated, more concise. They don't really go into a ton of detail, and they really shouldn't go into too much detail. It should be really kind of high level, but it should be where the investor can get a good sense of, is the business viable? Is it solving a solution, providing a solution for a need in the market? And does this seem like this would be a viable investment? Those are the things they want to get information on. So, do they really want to know the secret sauce? Do they really care? Yes, they'll care, but at the early stage, they may not really need to know that. And you also don't want to disclose anything if it's IP that you may go out and file a patent for. That's where you have to be really careful in what you disclose, because if you disclose too much, you could potentially be creating prior art, and now you've got a scenario where you've already disclosed something and you have sort of shot yourself in the foot because you can't now go and file a patent for that. So, a great example of mistakes that have been made where someone has got a great invention idea, they want to file a patent, they've already checked, they think it could be patented, but then they go ahead and publish a white paper on it, and the white paper is in a lot of depth and talks about the technology, talks about the invention, and then it gets distributed out. They've already disclosed it. It's become public in the public domain, that they're not going to be able to now go and file for a patent. So you do have to be very careful. And if you run across those scenarios, easy enough to tell the investor, look, I can give you sort of high level information, but I can't obviously disclose the invention itself because we're in the process of trying to patent it. There you'd want to talk to an IP lawyer, talk to a patent lawyer. They can give you great guidance on what you should or shouldn't say, how much you can say, and not run afoul of that. Okay, last question, or maybe a couple more. In regards to doing your homework prior to fundraising for an early stage, how many months of recurring growth would be deemed compelling, and how many consumers is considered statistically significant? Boy, that's a great question. I think it sort of depends on the type of business. In past, I've heard anywhere from, if you've got, over 100,000 consumers or users, if you will, and sometimes more than that, more north of 200, 250, 300,000 users, that's significant enough to start piquing some interest. But again, that's not really something I can answer all that well. Investors may have different takes on that. Some might want higher number of consumers or users. Some might want a little bit less. It also depends on the type of investor. If they're really early stage investors, oftentimes they're investing when there aren't any users, there aren't any sales, there aren't customers, there isn't even a product yet to sell. It's all, before proof of concept or just at proof of concept. So that really depends, but those are at least some initial numbers I've heard before. What are the legal backups for startup idea theft from university after discussion if it does not work? And I think this will probably be the last question we'll have time to take. When it comes to universities and working with universities, that's a whole specialized area, and you really should be getting advice from an attorney that has done work involving university transfer agreements or IP type agreements, licensing agreements from universities. And oftentimes there'll be technology that's developed at a university that's spun out into a startup because the founder was a professor or was a researcher at the university, came up with the idea, wants to commercialize it, sets up creates a startup, and then wants to license the technology that he developed or she developed at the university for their startup. Happens all the time, but there is a process to go through. Typically, if you're doing research, at a university, whatever you develop is the university's, absent some agreement that says otherwise. And so you start with that as sort of your default, and then you've got to go and talk to the appropriate authorities at the university to negotiate the licensing of that technology or the purchase of that technology so that you can go use it in your own startup. It's a complicated process, but you definitely want to make sure you do it properly and get good advice there. So with that said, I know we've hit the 1:30 hour. Great being here and talking to everyone. Thank you for your questions. Great questions. Happy to answer some questions offline if there's some folks that want to get in touch. My email's up on the screen there. You can find me on LinkedIn. You can go to our website and find my contact information and reach out. Wish you all the success in the world, whether you're an investor, whether you're a founder, entrepreneur, or you've been involved with a startup and helping make it successful. I wish you all the best in the days to come. And hopefully you got some good takeaways from this. If nothing else, do your homework. And we were all kids and had to do our homework because our parents would yell at us if we didn't. I won't be yelling at you if you don't, but just know that exercise of doing your homework is something that should be with you your whole life. So thank you very much, and hope to see you again soon.